My name's Anna Bennett. I'm a solicitor with Devonshires. I'm here with Katie Groman, who is also a solicitor. And we are going to present today's webinar aimed at more junior staff members, and it's all about disrepair claims today. So what you need to be doing when you get that fated letter of claim asking for all your documents and so on, what do you need to do? Even before then, you know, what you need to be thinking about when the tenants start raising issues and so on in terms of documentation and so on. Katie will be starting and she'll be talking about the law, and I will then go on to talk about what happens actually if the claim's issued. So Katie's going to go over what your statutory and contractual obligations are in terms of disrepair. Obviously, in terms of contractual obligations, it will depend on your tenancy agreement, but I'm sure Katie will go on to that. She is going to discuss the pre-action protocol for housing condition claims, which has fairly recently been renamed, sort of in the last year or two. And basically that forms the basis of everything you should be thinking about to do with disrepair. That is your Bible. And also she will go over using and engaging single joint experts. Then we'll have a break for a Q&A, and I have already mentioned to those of you lucky enough to get in a little bit early, if you haven't used Zoom webinars before, if you hover your mouse at the top or the bottom of the screen, it should bring up a menu. Within that menu there is a Q&A option. As and when you think of questions, do pop them down, type them in and send them to us, and we will respond in the break. So after Katie's session we're going to have a question break, and then deal with any questions you might have, any scenarios you want us to discuss. We do them on an anonymised basis, so unless you want your name in, then if you want your name in, tell us, but otherwise it'll be so-and-so's asked such and such a question. We won't be giving out your details. Oh, sorry, wrong slide. Sorry. That's my fault because I clicked on the menu. So I will then go on to what to do if a claim is issued. And really most importantly, settlement and costs. Disrepair claims, training on them starts to get a little bit depressing because a lot of it is about having to settle. Even if you think you've got an amazing case, usually there is a point where you do have to settle. So that is hopefully won't end on too much of a down note, but that will be pretty much the crux of my session. So I'm going to hand over now to Katie, and Katie will take it forward in terms of pre-action considerations.
The liability to repair arises under three key pieces of legislation. The first being Section 11 of the Landlord and Tenant Act 1985, whereby there's an implied repairing covenant for all tenancies and leases of less than 7 years. So these repairing covenants include keeping in repair the structure and exterior of the dwelling house, keeping in repair and proper working order the installations in the dwelling house for the supply of water, gas and electricity and for sanitation, and to keep in repair and proper working order the installations in the dwelling house for space heating and heating water. The next piece of legislation, which is also relevant for landlords' liabilities to repair, is under Section 4 of the Defective Premises Act 1972, which extends a duty to all landlords who already have a repairing obligation under the tenancy, and that's whereby premises affected by defects in the state of the premises, there's a duty for landlords to take such care as is reasonable in all the circumstances to see that they are reasonably safe from personal injury or from damage to their property caused by any defects. The next piece of legislation, which was introduced on the 20th of March 2019, is the Homes Fitness for Human Habitation Act 2019. So this introduces a new obligation for landlords where they need to ensure that homes are safe, healthy, and free from things that can cause serious harm. And it's amends Section 8 of the Landlord and Tenant Act 1985 for there to be this implied covenant for fitness for human habitation. For tenancies entered into before 20th of March 2019, the Homes Fitness for Human Habitation Act only became effective as of 20th of March 2020. And then for any other tenancies entered into after that date, it was effective immediately. But that is partly why you might have actually been noticing in more recent letters of claim that this is now being relied on more so since that it's been applicable to all tenancies since the 20th of March 2020. In terms of the express covenants for repairing obligations, landlords should always refer to the tenancy agreement. So firstly, to identify in each party's repairing obligations, finding out what's the responsibility of the tenant and what a landlord is responsible for. And also it's important to look out for maybe a higher standard of repair in these instances, because as you will note from the Landlord and Tenant Act 1985 in Section 11, the standard is keeping in repair. However, in this instance, there could be clauses within the tenancy agreement, such as keeping in good condition, which is a slightly higher burden. In terms of the disrepair procedure, often how a prospective claim will come about is a tenant might be wanting works done. They might feel that these are taking an unreasonable amount of time to be actioned and completed. And because of that, they might seek the advice of a solicitor. In that instance, the solicitor will advise that they'll then prepare a letter of claim and inform them that the tenant might be entitled to compensation if it is found that a landlord has failed to conduct any repairs within a reasonable time, providing that they would put on notice of issues of disrepair. In these instances where a compensation payment is made, or in other words, damages paid, there is also the liability on the landlord to pay the tenant's legal costs. This is essentially because by making the damages payment, it is an acknowledgement of liability that there was disrepair at the property for an unreasonable amount of time, and therefore the legal costs paid to the tenant is also the responsibility of the landlord. The first stage will be engaging in the pre-action protocol for housing condition claims, as it is officially now called, and I'll discuss that in more detail on a later slide. And then ultimately, if the two parties are unable to resolve this by engaging in the pre-action protocol, the next stage will be for the tenant solicitor to formally issue the claim in the county court. And it will be the county court which is closest to the landlord, to the property. Right, so in terms of the pre-action protocol, the key aim is really quite intrinsically linked with what is referred to as the overriding objective under the civil procedure rules. So it's really to encourage efficiency of pre-action engagement at an early stage. So that's sharing information, encouraging an early settlement, and also avoiding unnecessary litigation if it can be resolved without the involvement of the courts. The protocol very helpfully sets out the exact steps that both the tenant and landlord need to take when engaging with the protocol, and that's including the information which is to be disclosed and the process for appointing a single joint expert. One of the first steps that will need to be taken in accordance with the pre-action protocol is where the tenant solicitor will serve on yourselves as landlord a letter of claim which sets out the alleged defects. It also proposes a single joint expert, and it should append to the letter of claim a proposed letter of instruction by which you would instruct the single joint expert if it is agreed. In relation to experts, I'll go into that into a little more detail in our later slides. So in accordance with the protocol, the landlord has 20 days to reply to this letter of claim. If for any reason upon receipt of the letter of claim, you feel that you might need longer to respond to that, for example, in terms of obtaining the requested disclosure documents, which includes the housing file and the disrepair records, it might be advisable at as early a stage as possible to seek an extension where that is necessary, just to allow yourself more time. Also, in relation to providing a substantive response to the allegations raised within the letter of claim, that can either be done within the initial reply, 20 days after the letter of claim has been served, or alternatively 20 days after receipt of any expert report, in which you set out whether any of the alleged disrepair issues are admitted and those which are denied, and also raise any issues that you've encountered, maybe with the tenant not providing access when works need to be conducted, or failure to actually notify yourselves as landlords of any of the purported issues. The consequences of failing to comply with the pre-action protocol are, well, firstly, the courts themselves can look quite disfavourably if anyone really has gone drastically against really what's set out in the protocol. And also there's actually the risk still at the pre-action stage, if the disclosure duty has not been fully complied with, where the tenant solicitor has not been provided with sufficient records, which they believe there might be more that the landlord is retaining. A pre-action disclosure application could be made against the landlord, and that could actually result in a cost order. So again, it's important as at an early stage, once you're on receipt of a letter of claim, ensuring that you have compiled that information which will be relevant to the disrepair claim. Another issue which might arise from not properly following the protocol could be where any expert who was appointed and a report made, but again, not duly following what is set out in the protocol, issues could arise in terms of relying on that report, and the court will need to give permission to rely on any expert reports in those instances. And yep, just as a key note, the protocol does not apply to counterclaims. So counterclaims meaning where, for example, a possession claim has been issued, and quite commonly a counterclaim will then be issued because a tenant representative will ask the tenant, when they are facing possession proceedings, have there been any issues in terms of disrepair with the property, and then any potential damages could maybe be offset against rent arrears if the possession claim was linked with rent arrears. So using a single joint expert, again, as said earlier, it's really useful to keep cross-referring back to the pre-action protocol, just to ensure that you're monitoring the rules. So a single joint expert is encouraged, and it should be proposed within the letter of claim. But there might be instances whereby it's not appropriate to actually appoint a single joint expert at that time. So for example, if the issues in dispute are not actually related to the alleged disrepair, but there's only a dispute over the amount of compensation or damages that the tenant is to be entitled to, a single joint expert in that instance might not be appropriate. Also, if as a landlord, you've very recently already obtained a surveyor's report which sets out the condition of the property, it's useful to raise that at the time when you're responding to the letter of claim and potentially suggest withholding from instructing a single joint expert at this point, so in the interest of saving costs, and then for the tenant solicitor to maybe review that report and then determine whether they think that's sufficient for attempting to resolve the matter prior to resorting to instructing a single joint expert. Whilst reviewing the letter of claim and the proposed single joint expert, it's also helpful to just ensure that the expert is appropriate for the type of disrepair that is being alleged. So, for example, an environmental health officer would not be appropriate in a standard disrepair situation. And to retain that element of control when responding to the letter of claim, if you as a landlord have a preferred expert, then put that forward, explain reasons why you believe this expert will be more appropriate, and provide a copy of the CV at the earliest opportunity. Where the landlord doesn't raise any objection to the proposed expert that is set out in the tenant's letter of claim within 20 working days of receipt of the letter of claim, the tenant is entitled to proceed with instructing that expert as a single joint expert in accordance with the proposed letter of instruction, which again is why it's important to review the proposed expert, look at the letter of instruction and make sure that it's drafted in an impartial way where it's going to adequately address the relevant points. So again, this is set out in the actual pre-action protocol, but the single joint expert should be commenting on the disrepair that is raised within the letter of claim and its cause, and provide the schedule of works together with the estimated cost for those works, which can then be mutually agreed between the parties. And then ideally, as soon as possible, those works are then conducted so that there's no, so that the liability for disrepair does not go on more than is necessary. In terms of an indication as to whether the tenant will need to be rehoused for the duration of the works, that should also be commented upon within the expert report. That's everything from my end. So at this point, we'll take a pause and pick up on any questions that have been raised.
Do you want me to? I'll pick up on the first question.
Okay, brilliant. Thank you.
Okay, just to let you take a breath. Okay, so the first question is, when requesting an extension for the reply to the initial letter of claim, is the extension at the discretion of the tenant solicitor or governed by the protocol? At the letter before, pre-action stage, really it's at the discretion of the tenant solicitors. So you might get some who are very aggressive and might be pushing for the information. I mean, you do have quite a decent period of time to get together your documents. What I tend to do is certainly provide all the disclosure and so on, just checking there's nothing too sensitive in there, but all the relevant information. But I tend to withhold on liability because I say, well, we'll wait till the experts report and then we'll take a view on liability. But yes, it is the discretion really of the tenants' solicitors, save that if they issue a claim and you are fighting about what's been going on and getting access and getting works agreed, obviously if you've asked for an extension for good reason and they've refused it, then I think you could flag it up, but equally they could flag up on the other hand that you'd not responded within the protocol and it may be taken against you, but it depends entirely on the facts of the case. Katie, anything to add?
Yeah, well, I was just going to pick up on one question which has also come in from Michael, and the question is, what can a landlord do if the protocol is not followed by the tenant? So in the pre-action stage, what I would advise, whether your organisation is dealing with it internally yourself or if a solicitor is instructed, can just be raised within correspondence with the tenant's representative that the protocol has not been followed for whatever reason that may be, for example, instructing a single joint expert at too early a point, or even maybe providing a report from an expert and seeking to rely on that even before a letter of claim is served, and just drawing attention to the fact that where the protocol is not followed, if claim is later issued at any point, the court, your intention to draw this to the court's attention as to how it's not followed, and maybe seek cost consequence. There will be cost consequences against that.
Okay, I'm going to pick up on one that's just come in at the bottom, because I think we've got a little bit of time. Oh, hang on. Sorry. I've lost it at the bottom. Regarding single joint experts, where we were unaware of the need for repairs, can we refuse the appointment of expert at this time? Not really, but what you could offer to do if you've got good surveyors working with you is say we want to send our own surveyor in, and we'd ask that you hold off the agreement of the appointment of a single joint expert until the surveyor's been. And if what I find with my clients is those who have surveyors who have the time and the facilities to actually carry out post-inspection work in terms of putting together a really good report and schedule of work. So if you can, if your surveyors can provide that and you can send that to the other side, then quite often the other side will be prepared to agree it, so long as it's very clear that your surveyor's being as impartial as they can be. I mean, it wouldn't be considered a Part 35 expert report if you ever got to the court, but it may be sufficient in terms of the lawyers basically looking at the condition of the property and being able to determine the value of the claim, I would say. So it's worth sending a surveyor in, I'd say, initially. Katie, do you want to pick up on another one?
Yeah, I was going to pick up on one more question if that's okay.
Yeah, sure.
So something's come in from Rachel, and the question is, should you object to the instruction of an expert where you have no record of any complaint being made by the tenant prior to the letter of claim, in brackets, though the tenant says they have phoned to complain, on the basis that the protocol is not properly engaged with without the complaint being made first? So in terms of the tenant actually putting the landlord on notice of any complaints, that's actually a separate issue to following the pre-action protocol, and that's something where it is certainly valid and it is a defence as a landlord which can be raised in the substantive response to the letter of claim, but regardless, that can't then be used as a way to dispute the appointment of a single joint expert, and it probably would be actually beneficial to both parties to then have the expert go in so they can review the position, draw up the schedule of works, and then identify firstly if actually there is disrepair, even though as an organisation you might not have been notified of it, and then conducting the works proposed in the schedule by the expert so that it can be rectified as soon as possible, and also then protect you against any future claims arising, which if these works were to go unrectified.
Okay, I'm just going to pick up on one more question, then I'm going to push forward with the next slides. We might mop up some questions at the end anyway, as well as obviously you can keep asking questions as I go through my section. Just because I've got a very quick one, is there a minimum or a maximum fee for the survey? There's no official minimum or maximum fee as far as I'm aware, but I generally, with my experience, would say it varies between, say, about £600 to £1,200. Katie, do you reckon that's
I would
right?
say that.
Yeah.
Pretty much, yeah.
Bear in mind, obviously, as a single joint expert, you would be responsible for half the fees. However, there's a good chance if any disrepair is found that you'll be paying for the whole thing. So, you know, if cost is a consideration, then it's something that you could validly raise as an objection if one expert is significantly more expensive. Save that, they might be significantly more expensive because they're really experienced and really do provide very comprehensive reports. So it's a cost-benefit analysis, really. Okay. I am going to take us forward and we are going to talk about, I'm just going to move my Q&A screen so it's not blocking what I can see. I'm going to move forward to well, I will in a minute, litigation. So what happens after your tenant issues a claim? So this is assuming you've not managed to settle, and I'm sure Katie has touched upon, but generally the goal is to settle these claims as soon as possible. I will come on to explain why when we talk about costs, but generally, if tenants' lawyers have picked up a case, quite often these days it's on a no-win, no-fee basis, and it means that they think the claim is, sort of 60% likely to succeed. So there's a good chance there's liability there. If even if it's fairly minimal, if there's no arrears, basically costs follows the winner in litigation, so you will end up paying their costs. So it's always in the interest of the landlord. Well, not always. I'd say 95% of the time it's in the interest of landlord to be thinking about settling early and to get the matter done and dealt with. In terms of getting works done and starting negotiations on settlement as soon as you can. Okay, so you haven't managed to settle for whatever reason. You either think their claim's just not worth it, or there's no loss there, or you don't accept you've got liability, or the tenant's lawyers are incredibly aggressive and they've issued perhaps a little bit early, which you might want to raise in your defence, or a defence and counterclaim potentially. So they will issue a claim against you in the county court. They can look for an order for works, damages and costs. The reason we advise clients to get works done as soon as possible is that if you get the works done, then it removes their remedy for specific performance, i.e. they can't get an injunction against you to compel you to do the works. Once you remove that, if there's not much in the way of damages left, then it becomes a money-only claim, and we can have arguments about what track it gets allocated to. There's basically, I don't want to complicate things too much, but basically there's 3 tracks at the county court: small claims, fast track claims, multi-track claims. If it's below a certain value and it's a money claim, then we can argue it's a small claim. And if that's the case, then they can't get costs. So that's why we think, oh yes, we'll try and get the works done so we can remove that possibility and remove the attraction for tenants' lawyers to actually issue a claim against you. The alternative way that claims get raised is counterclaim within existing proceedings, usually a rent claim. So your income team will have issued a claim. They may or may not have checked in with you, but if they had checked in with you, perhaps you've not actually had any reports recently of issues. However, the tenant has arrived at court, they've spoken to the duty advisor has gone on through all sorts of things, and they will have asked things like, is there any mould in your bedroom or bathroom? And frankly, lots of us will say, well, yes, actually, because quite often a little bit of mould around the grouting and so on. That will be enough for the tenant's lawyer to jump up and down and say, actually, Judge, we want to defend this. We think there's a disrepair claim here. No judge, given the time constraints to any first hearing, is going to listen to the evidence there and then. They will adjourn the claim for the tenant's lawyers or the tenant to put in a defence. Then your tenants will put in the defence, and basically they'll raise all sorts of issues which you either are or aren't aware of. It may be that it's perfectly valid, or it may be that a lot of it is stuff they might have mentioned historically, but certainly hasn't been raised recently. Unfortunately, quite often there's something, and it something they can rely on, and it is slightly annoying, because you then get into a point where you're looking to settle perfectly valid rent claims. Save that if their loss is really low, then arguably you should still be pushing ahead to trial, because it won't offset the arrears if they're in excess of a certain amount. So in terms of litigation, what do you need to do? So you receive your claim form. It shouldn't be a massive surprise to you. You would hope the tenant's lawyers would let you know, but as I say, some firms of solicitors are quite aggressive, and they just launch these claims because they think, I don't know, they're worried that it's not going to settle or something, so they think, I'm going to put the heat up, I'm going to issue a claim. You should firstly think, well, firstly, get solicitors involved if you can. If you can't, speak to your legal team. But an acknowledgement of service needs to be filed ASAP. If you can do that within 14 days of the claim, then you get another 14 days to file, well, basically to put together your defence. So you might need that extra time, especially if it's brand new to you, because you need to look back through the files. You need to ideally send someone down there to look at the property, survey it, and actually see if there's any veracity in what's been done. And then you need to speak to whoever's drafting defence, get it all done, and it needs to go back to court within 14 days if you've not filed an acknowledgement of service, or within 28 days if you have. So you do get a bit of extra time. You need to hit that deadline, because the danger of not doing so is that you get default judgment against you. Having said that, default judgment is never going to be that default, because it's very rare that a disrepair claim is pleaded sufficiently clearly that someone is actually seeking a particular amount, because general damages, which I'll come on to, it's not a known quantity. So unless there's particular items that have been damaged, usually it will be between, they will be claiming between 5 and 10,000 or 10 and 15,000. So there would need to be a hearing to actually assess the value of the claim. But as I say, you don't want to miss that deadline. You need to get the defence filed. After the defence filed, the court will look at it, the judge will look at it, and they'll say, okay, I've got my claim form, I've got my defence. I may well have a reply if we put in a defence to counterclaim. You might want to counterclaim, for example, if there are rent arrears, you might want to put that into a counterclaim, because then you can potentially get set off in any settlement agreement. The court will then basically, they should allocate it to track. So they'll say it's a small claim or a fast track claim, very unlikely to be assessed as a multi-track claim. They will, so that's where they'll ask you to file and serve allocation questionnaires. But as I say, the claims that I've had recently, the judge has taken it upon themselves, looked at the papers, and obviously allocated it to track without actually asking us. Then there will be a provision for disclosure. So by both parties, standard disclosure. You would have sent most stuff anyway if they've been following the pre-action protocol, but you need to send it all again you need to list it all again, and then the tenant's lawyers might ask you for any additional documents. You need to make sure it's up to date. And there will be provision for basically obtaining or updating expert evidence. So quite typically when a claim's issued, it'll be the claim form, the particular claim, and quite often tenants' lawyers will attach an expert's report. So the court might refer back to that, or they'll make another order that it's for the parties to agree a single joint expert, and for an updated report to be produced for the parties in the court by a certain date. After disclosure, then at that point you get to exchange witness statements. So this is your opportunity to put together all the evidence. So you usually will need evidence from some kind of maintenance manager, someone who's got control of basically sending contractors down, and what the contractors have done, can basically put everything together, show all the works that have been done, refer to all the repair records, how often you went. Also very important to highlight access issues, so where the tenant's been refusing access, that is really important to note. And also where you might be saying, well, they're saying they've given notice sort of 6 years ago, or since the start of the tenancy they've been complaining about this. Actually, when you look back at customer services records, repairs records, the first report was, I don't know, May 2020, so it's actually not that long ago. So you acted reasonably, you carried out the works within a reasonable period of time of notice being given. So that's your opportunity to put forward your evidence there. There's then provision to file and serve a pre-trial checklist. That is literally a procedural form for the courts. Basically, you're confirming you've carried out your disclosure, you've done your witness statements, that you'll be using counsel, any dates to avoid, that kind of thing. Once they've had the pre-trial checklist, or possibly before, then the court will set a trial window date, or maybe even a trial date. As mentioned, most disrepair trials are allocated to the fast track. That means the court thinks it can be dealt with in a day or less, which would be true for many straightforward disrepair claims anyway. If it's more complex, so for example, if it's actually a disrepair counterclaim, and what's happened with a couple of my clients sort of within the last year was having disrepair counterclaims, but also Equality Act counterclaims as well, on the basis they couldn't pay their rent because they were anxious, and also there was disrepair. So there it starts getting complex. Then those cases were allocated to multi-track, because basically as soon as Equality Act type issues are raised, then there needs to be an assessment as to whether there is a disability there potentially. If there is a disability, how it would impact on their ability to pay rent, or how it might impact on the effects of the alleged disrepair on them, and so on. So it does start to become more complicated. So it becomes a multi-track case. So in terms of defences, the types that you see, as I say, for freestanding claims, a good solicitor is not going to issue a claim if they don't think they're going to win. So they will have looked at that claim, they will have decided that they think they can prove that case, they think you are liable. I would say at least 60% certain that they're and happy that they would win that claim. So for claims that have been issued not on the back of a rent claim, then I would say there's usually some merit to them. I suggest you get the papers to legal advisors as soon as possible, so that they can prepare their defence, and so that also they can look at the claim and maybe look at the appointment of experts. So as Katie mentioned, quite often solicitors on the other side might, rather than offering a RICS approved chartered surveyor as a single joint expert, they might offer an environmental health surveyor. Even if a claim has environmental health aspects, you still really want a chartered surveyor to be able to assess whether you're in breach of any repairing obligations if it is a disrepair claim. So in those types of cases, it's lovely if you can get someone who is an expert in both, and there are experts out there who are both. But I would say out of the two, the chartered surveyor, for a disrepair claim at least, is the one to go for. You need to provide all the documents you can. I mean, you're obliged to. You have to provide all relevant documents, even if they might harm your case. You are under that obligation to disclose. And obviously with the right information, then your lawyers should be in a position to advise on liability and assess quantum. That's really important to try and get the case settled as early as possible without having to incur all the costs associated with further disclosure, preparing witness statements, looking, actually getting to the point where trial, putting all the bundles together, getting counsel booked and briefed and so on. As I say, certainly with freestanding claims, there's usually a lot to be said for settling early, if you can. So, as I say, other defences open to you potentially are things like it's not disrepair, i.e. it might be condensation. You might want to be a bit careful about that because there may be fitness for human habitation type claims in there if they can show the property itself needs improvement works and there's something open to you. So yes, you could raise it, but actually if there's improvements you could do to address that, then again they may well have some validity to those claims. So not landlord's responsibility, tenant damage. Most obviously these would be things like, I don't know, holes in walls at basically waist height or head heights that are inexplicably there. I think it's quite hard for a tenant to argue that you would have caused that unless they can show you contractors have been in and it happened after that. But even then, it's very unlikely that's going to be your fault. Things like broken cupboards or doors hanging off, if it's not for fair wear and tear, i.e. hinges just getting a bit overused, or if they've not been put on properly, then there may be a chance you can argue that it's tenant damage here. Most typically are things like failure to give notice. So they've said, as I say, oh, we gave notice in 2016 that this was an issue and we kept on giving notice because it never got solved, but actually you look back through the reports and you've got customer services records, for example, where people are calling in about rent or other issues or ASB, but no mention of their disrepair. The lack of any mention would imply that actually they're not really suffering any loss because they're not reporting it. It's clearly not annoying them to the extent that they're raising it with you, and you don't have any records. So that in itself might constitute failure to give notice. Failure to give access. So if they're refusing access and there's no good reason why they're refusing to give access, then that is a potential defence. Save that, I would add, it is incumbent on you as the landlord to show that you've done everything available to you to get access. So if somebody is failing to give access for reasons that just are not reasonable, so because you as a landlord have the right to go and carry out works to your property. If they're not giving good reason, then you need to be threatening them with an access injunction. You should be sending a letter before action. You should be mentioning this to their solicitors. If that's still not working, then you really should consider actually issuing proceedings against them for an access injunction to show that you've done all you can. And once you've got that injunction in place, that then carried out, well, if they're still refusing, then that really would go to a good defence to the fact that you've not managed to do the repairs they're asking for. Also, failure to mitigate loss. So tenants quite often complain about mould and dampness in their, say, bathrooms. Are they wiping it down? Are they doing what they can? Are they using bleach to try and address the problem? That kind of thing. Yes, basically anything they could do to try and address that issue. They need to show they've mitigated the loss as much as they can. They've actually tried not to suffer as much as they could have done due to that particular issue arising. So as I've mentioned quite a few times, settlement is really the aim of the game. If you can, you might get the odd case where you actually think, no, this is not acceptable. We don't accept liability here. We're going to push it all the way to trial. But in many cases, it is really important to look at settlement and seriously, and actually look at how you can, what could be offered to the tenant to get this claim off your back. So you need to think about what they might want. It's not always money. It does obviously come into it, but sometimes tenants have other reasons for issuing claims. It might be that actually there's 4 people in a 1-bedroom property, and they've been on a housing list for months, if not years, and they want to get out, and they think that the issuing a claim will be enough to help them do that. And it might be that actually it's not within your power. You don't have the stock to be able to move people willy-nilly, but it is important to recognise that in your conversations with tenants' solicitors, if that is part of what they're looking for. Of course, look at the value of the claim. So that's where you look at the quantum, which I'll come on to shortly, where the damages that can be offset against the arrears. So they might have a claim which you think, oh, it's worth about 5,000, but actually they've got arrears of 2.5, or the other way around, you think their claim's worth 2.5, but actually they've got arrears of 5,000. Then actually fine, we'll offer the arrears a full set off. We might even do it as an open thing, but we still want to get possession of this property because you're still £2,500 in arrears. And making an offer under Part 36 of the Civil Procedure Rules. Now, Part 36 is where you make an offer and it's got cost consequences. So if you as the defendant make an offer to settle a claim, it's always best to make a generous offer if you can, but say you offer 5,000, you think the claim's worth 4. If they get to try, and they refuse that offer, they said, no, I want 7. If they get to trial and they get 4.5 or £4,990, then you will still have to pay their costs up to the time the offer expired, but they will be liable for costs after that expiry date. So it puts a bit more onus on the tenant's solicitors, basically, and the tenant to take those offers seriously and to accept them in a timely fashion. Now, quantum, so it isn't an exact science. So there's no particular tariff. Cases would they'll look at previous court authorities, save that the fact that all these cases are so fact specific, so it's very easy to say no, that's not applicable in this case. Generally, when I'm assessing claims, I'll look at diminution in value, which would be basically a percentage of the rent. So I can see that they reported problems with, I don't know, a leak to their top room. I will offer them, I don't know, 10% of the value of the rent for that period until the works are completed, which is, say, £1,500. We might have a bit of argument going back and forth, but that's how the starting point will be. It'll be to do with the rent and percentage-wise of that rent. There's also overall damages rates when looking at damages, but which generally is between sort of 500 per annum to maybe 3.5 per annum. Most cases are valued between 1,500 and 2,500. Obviously, it completely depends on the rent. So, for example, if you have properties that are temporary accommodation and let through private owners, those will be a lot higher because they will be paying near market rent as opposed to social rent. So, do bear in mind that that figure is, well, it's not strictly correct. Okay, so when you're looking at settling a claim, and I'm going to try and speed it up so we've got time for questions, you need to think about everything. So you need to think about general damages, which is the diminution in value. You also need to think about special damages. So say someone's complained about a leak, and there was a leak and it ruined their sofa, then you need to be thinking about the value of that sofa and offering compensation for that. They need to prove that something's been damaged by something that was your fault. And to do that, they show you receipts of how much it cost them, or receipts of how much it costs to replace that item, and photos of the damage and so on. And again, they'd be expected to mitigate loss. So say, as I have seen, someone is complaining they have shoes in a cupboard, it's gone a bit mouldy because there was condensation, maybe there's a boiler in there, or there was a slow leak coming from the boiler, and all their shoes are ruined, and you look at the shoes and you think, well, there's a bit of mold, but they could have wiped them off, you know, or there's some clothes, they could have put them in the washing machine. So you can make these arguments. You do, with costs, I would say, unless there's a massive amount of arrears, the best position is probably from the outset to say we're happy to pay your costs, because that, not wanting to paint all tenant solicitors with the same brush, because most of them are acting in their client's best interest, but a lot of tenant lawyers are mainly interested in the fact that they're going to get paid for their work. So if you say from the outset, we will pay your client's costs to be assessed if not agreed, you'll often find that magically settlement happens a lot quicker. You need to take into account of any arrears. So if there are arrears, then you want to basically, you can credit your rent account first, so bring that back to zero. It's in the tenant's interest to do that because it removes any potential possession right you may have against them. You also need to look at the works, if anything's outstanding, how long it's going to take, and factor in a bit of extra time for snagging and so on. And also anything to offset, so anything that the tenant, you can show actually the tenant caused this damage, then anything that might be rechargeable under their tenancy agreement. So if there's a clause in there saying that you could recharge for works that is caused as a fault of the tenant, then that should be factored into settlement as well. As I say, I've mentioned Part 36 very quickly, but yes, it has consequences, so you should be thinking about making offers early, especially with cases that have been issued and look like they're going to be going all the way to trial. If someone's publicly funded, they've got legal aid, then what we sometimes do is write to the legal aid agency. When a reasonable offer is refused, we then let the tenants know, let the lawyer know what we've done. So we made this offer, they've refused it, we don't think they're being reasonable, and then potentially the tenant's funding can be withdrawn. Usually that doesn't happen, or if it does, it's after the event, it's far too late. However, it may well again get the tenant's lawyers to seriously think about a settlement where they weren't particularly engaged previously. Yes, and so do consider all aspects. And the reason costs are so loaded against landlords is often because there is a bit of liability there, but also with legal aid, even if you win your case, you're not going to be able to recover costs against that tenant anyway, because they're not somebody of means. So the cards are slightly stacked against landlords in these types of cases, unfortunately. Okay, so yes, as stated, the losing party will pay the winning party's costs, usually. You will get some protection by using Part 36. And as I say, the issue is you might never recover costs even if you win a claim, because you're against somebody who doesn't have the funds. Okay, so we're going to move on to questions. Katie, could you pick up a question for me, and then
Of course, yeah, I'll just pick up one which has come in. So this is, what can you do about some firms who issue claims and items which the tenants have not reported, such as a roof leak for a ground floor flat? So in an instance whereby you actually think the claim is completely redundant and the allegations are untrue, or the nature of the disrepair couldn't actually affect the property, so in an instance like a ground floor flat where they're claiming there's a roof leak but it isn't detrimental to that property, the best thing to do is write a very robust response to the letter of claim, setting out why there isn't a valid claim for damages, and also that there was a failure by the tenant to report that. So again, which that is a valid defence to any disrepair which is existing in the property if it was not reported at any point previously. Again, similar to what Anna had touched upon, in those instances, often a tenant solicitor will make an assessment of the prospects of succeeding with the claim, and it usually needs to be above 50%, particularly when they are taking it on a no-win, no-fee basis. So really, if you strongly believe or are very confident that this the claim is really redundant, then yes, by all means, write that robust letter, and they really shouldn't be issuing, because they wouldn't win at trial in that instance. So, yeah.
Okay, I'm going to pick up just one at the bottom. Going back to pre-action, we received a pre-action letter, and tenant authorisation basically the signature bore no similarity to that on their records. They're a bit concerned that it's not necessarily the tenants that signs that form. If if that's a concern, then that's something that needs to be raised with the tenant solicitors. So I would say we note that we've got this tenant authorisation form. However, according to our records, and I would provide them with a copy of the tenancy agreement or whatever you have that's got the tenant's signature on it. This is not the same. Well, it's not the same signature. We're concerned it's not the same person. Please, can you take your client's instructions? But we won't be corresponding with you any further on it until we're satisfied that you have the authorisation of the genuine tenant at this address. Then I'd carry out some investigations, just check the tenants are there, there's nothing a bit funny going on. And obviously, if send a surveyor down to sort of raise any works orders and start works as soon as you can. Katie?
Yep, I'll just pick up on one other question. So it is, for allocation purposes, would arrears be counted against other damages? So say damages are valued at 1,500 and the arrears are 1,000, would it be valued at 500? So again, Anna did pick up on this in her part, and the answer is yes, most definitely. But what is quite useful or important to actually remember to do is, in any offer of settlements that are put forward, caveat your offer of damages that it is to be first offset against any rent arrears that might be in existence. And again, make sure that's contained in any settle agreements that are entered into. So that just protects the position, and that then the amount is first deducted from the rent account to put it into a out of rent arrears, and then any outstanding amount is then paid directly to the tenant in the form of damages.
Okay, we are coming sort of near to the end of our allocated slot, but I'll just pick up on maybe one more, and then Katie can pick up on another, and then we will pick up on anything particularly pressing, and obviously you're always welcome to email us if you want to follow up with us with any particular queries, or use the advice line, but I'm always happy to chat about these cases. So I've just got a question, nice quick one. If the tenant has been evicted and files a disrepair claim, can we offset the arrears owed against this claim? Well, if they've been evicted, then the claim would be for money only, because obviously claim for specific performance makes absolutely no sense if they're not there. So yes, you can apply with a counterclaim with the rent statement showing the arrears owed when you put in your defence and counterclaim. So yes, of course you can apply to offset. And it should be a money claim only, so depending on the value of the claim, then you could probably argue it's a small claim as well. Okay.
I'll just take one last question. So that is, if we need to rehouse the tenant, which was not obvious at the beginning, are we as landlords eligible to extend the deadline to complete the works required? So as soon as it has been identified that the works in accordance with any agreed schedules and timeframes are to take longer than what has been potentially agreed in the settlement agreement, or if there's been an order for specific performance. In both those instances, it's crucial to write to the tenant solicitors, updating them of the position and explaining why the extension is required. And in an instance like that, whereby a tenant is required to be decanted and maybe the works are of a larger scale than initially anticipated, that should be deemed a reasonable reason to request an extension and should be granted. But again, as a first step, that's what you need to do, seek an extension.
I'm just going to pick up on one last one, just because I think it's quite an important point, and then I think that'll be the last one. Basically, can the claimant solicitors require you not to carry out any repairs or contact the tenant either pre or post issue once they've sent the initial claim, letter of claim under the protocol? Okay, strictly speaking, if the tenant has solicitors, then you should just go via the solicitors in respect of what is claimed under the letter of claim. That doesn't stop you from talking to them about anything else raised. However, I would often argue back against that and say, no, we need to get access under our obligations under our lease. Basically, we require access. And basically, they can't refuse repairs because you have got the right to carry out repairs into the property. So if the tenant's refusing access, the claimant's lawyer is being unreasonable, then I think you need to ramp it up, start threatening injunction proceedings, and just referring back to the tenancy agreement, the fact that you've got the right to get access under the lease. Yes, they can request that if there's valid reasons, but as I say, on a practical level, I think it's worth pointing out that actually in terms of the repairs to be carried out, you want to be able to contact the tenant to get access, and you think it's reasonable to do so. If they insist, then carry on, but just in terms of injunction, then any letter before action would need to go to the tenant directly and not to the claimant solicitors. So you should raise that point and say, well, actually we'll be taking our rights under the tenancy agreement to gain access. Okay. Well, we didn't get to all the questions, but hopefully we've answered enough that you've got a flavour. And as I say, you can always contact us afterwards. I hope you've enjoyed the session. I think the next session that we're going to be doing is non-occupation in a couple of weeks. So for those, you might want to mention that to colleagues who may be on your housing management side to sign up. Okay, thank you very much.
Thank you, everyone. Bye.